Good afternoon, everyone, and welcome to this afternoon's webinar entitled COVID and Divorce 12 Months On. My name is Graeme Fraser and I am a partner and head of family at OGR Stock Denton. I'm delighted to introduce our guest speaker this afternoon, Max Lewis, Barrister and Arbitrator at 29 Bedford Row Chambers. Max's practice covers all issues of family law with a particular emphasis on matrimonial finance and Schedule 1 cases. Max, if you could go to slide 2, please. During today's webinar, we will be covering the following topics: reported case law during COVID-19, what new clients are reporting in terms of separation and divorce due to lockdown issues, what will never be the same for divorce lawyers again when the lockdown ends, what could improve when we are out of lockdown, and some professional practice points and the future outlook for divorce lawyers. And as I said just before other people entered into the gallery, as it were, if you have any comments to make, please add it to chat. This is an interactive webinar and we will pick up any questions as well. So I now hand over to you, Max, and you need to go to slide 3.
Thank you, Graeme. And hello, everybody. Thank you very much for joining Graeme and me for this seminar this afternoon. And one of the things, well, the seminar is really in 2 parts. The first part is to discuss a couple of developments in case law that have happened over the last year or so while everybody's been busy worrying about lockdown and social distancing. Once the court got its head around the idea of remote hearings, actually, things have been pretty smooth. And one of the things that we're going to be talking about a bit later is that for some people, there are actually some very, very positive and hopefully long-lasting benefits that are coming out of all of this. One of which is that the development of case law seems to be trotting along. And I want to perhaps spend the first 15, 20 minutes talking about things that have absolutely nothing to do with COVID at all, but just to make the point that the law has been developing while we've all been locked down in 2 or 3 particularly interesting ways. Then there's one particular case I want to talk about, COVID, where COVID has made a difference in a financial remedy case. And then after that, I think Graeme and I are going to have a bit of a looser discussion, I think, about what we've learned and where we're going as a result of the recent coronavirus problems. So the first case I want to talk about is called De Halle. It is a decision, I think, which is absolutely worth reading. It was handed down by the Court of Appeal, just over a month ago. And what's interesting about De Halle is that it's a very good object lesson in how to make sure that the problems that arise if you don't do your drafting properly. The problem in De Halle was a very long-running, very angry case in which Miss Justice Holman had, a couple of years ago, approved a consent order between Mr. and Mrs. De Halle. That consent order included an order for sale of the matrimonial home. Now, the matrimonial home was in the husband's sole name and the wife was living there. So pausing there for a second, every family lawyer thinks to themselves, hang on a minute, that means that Mrs. De Halle has some home rights. She's got the right to be able to occupy it. But that is only good enough until decree absolute. And so you had this problem that there was a property in which she and the children were living, the husband owned it, and the home rights had vanished because of decree absolute and nobody had bothered to extend them. Now, this property, there was supposed to be an order for sale. The property wasn't selling, and it wasn't selling because I've said there, anybody remember Brexit? You know, when Brexit was the big earth-shattering problem, I think coronavirus has probably put Brexit into some kind of focus now and some kind of context, because there are things that are bigger, I think, nowadays than Brexit. But Brexit was the problem and it wasn't selling. The problem was that there was nothing in the order that talked about the basis of Mrs. De Halle's right to occupy this property. The husband, who by all accounts from the order was a bit of a swine, said, well, we've had decree absolute now, you've lost your home rights, I'm going to sue you in trespass. I want damages from you because you are living in my property without any rights. And a person called Judge Gerald who I haven't come across before, and I suspect that's probably because they don't do very much family law, said, yes, that sounds sensible to me. Until once decree absolute has been made, your home rights have gone. You are a gratuitous licensee, and you ought to be paying some occupation rent. They went to the High Court, the Chancery Division, where Fan Court J disagreed and said, don't be so ridiculous. Of course, she has the right to be able to live there. She's got to meet the outgoings, but she doesn't have to pay any rent. He then, Mr. Dahaly, brought an appeal that went to Lady Justice King in the Court of Appeal, all about what rights everybody had to occupy a property which had to be sold when there was no order and nothing in the order which specifically dealt with it. Oops. So Lady Justice King reminds us about two very important things. The first important thing is that line from Lord Sumption in Preston Petrodale, which I quite like and I trot out once in a while. Courts exercising family jurisdiction don't occupy a desert island in which general legal concepts are suspended. If a right of property exists, it exists in every division of the High Court and every jurisdiction of the county courts. Doesn't exist anywhere. And that includes now, post taking out the family court. We're always being told that there is no special law in the family division. If you have a right of occupation, if you have a lease, if you have a license, it is the same in which, or the legal effects of it are the same in whichever part of the English legal system you are arguing about it. And then remember a slightly lesser known strand of authority, which family lawyers have really traditionally not really dealt with in the same way. A case called G and B. This is the important bit out of Dahaly. It says when you're trying to get to the bottom of what a consent order means, i.e. what are the rights, did the wife have a right to occupy even though it wasn't written down anywhere, the way you construe a consent order is the same as the way you construe a commercial contract. You look at what a reasonable person, circumstanced, he says, as the parties actually were, so which simply means, you know, in the position they were in. What would they have understood the parties to have meant by a particular language? And the answer to that is you look at the text and then you look at the relevant contextual sense. Now, there's a whole line of authority recently about how you interpret and how you construe documents. A famous case called Chartbrook, judge of Lord Hoffman a number of years ago. The big important rules are that when you're trying to understand what a consent order means, subjective intention doesn't matter. Whether or not something was imprudent or a bad deal doesn't really matter. It's not the function of the court when it's trying to understand what something means to try and relieve somebody from a bad deal they've come into, unless it's hugely unfair and you're exercising that jurisdiction. But just because it might have been a bad deal or it stinks a bit, you're still looking for what the relatively objective phrasing and the objective meaning of that agreement was. And really importantly, it's no function of the court to rewrite any deal when it's trying to construe a contract or a consent order in an attempt to assist somebody who's cut an unwise deal or to penalize somebody who's pulled a bit of a fast one. Now, I think when it comes to this line of authority, this business at the bottom about G and B, we're going to have in the future a lot of conversations with clients when their prenups come to be tested. So prenuptial agreements really have certainly since Radmacher, they have become much more common and much more technical and much more detailed. And what's happening now, speaking to various lawyers that I know, different sorts of style of prenup are beginning to emerge. You've got those who have a rather kind of boilerplate standard. Here's what is matrimonial property, here's what's separate property, here's what's marital property. There are those who are a bit more creative about things, but there haven't yet been a massive glut of cases where the precise wording of those are being tested. Those are coming, and I suspect what we're going to find is that a great deal of, a great number of prenups weren't drafted by people who are used to drafting commercial contracts. I think, and I say this as a family lawyers are occasional. Well, we don't draft in the same way that commercial lawyers draft. And I fear that may come in the long run to come and bite us a bit on the bottom. as a result of all of that. Now, it does leave open the problem, I think, carrying on with Justice King's judgment about what you do, how do you interpret orders that haven't been made by consent. But nevertheless, in this particular case, where of course, if it's not been by consent, you're trying to construe what the court meant rather than what the parties meant. In this case, it was pretty obvious what the background context factors were. The wife was living there because that was her home. The judge had exercised a Section 25 jurisdiction. It was pretty clear that the purpose of the order for sale was to give the wife some money to go and buy a future house for themselves with. So the relevant background context to all of this was that she was living there because she had nowhere else to live. But if you have other cases where people are selling properties and there is money elsewhere, for example, where a house is being sold in the same sort of context, but it doesn't need to be sold to provide for somebody's housing needs because they can meet it from other resources, then Dahali is a bit of a warning sign to make sure that you get your definitions right about who has the ability to occupy, and you make sure that you think about all of these things. Otherwise, as I say, it may well come and bite you. This is not just theoretical. I think there are particular problems with definitions in court orders and consent orders that we use. I still see people when they draft their orders saying, I will agree to pay maintenance until my child finishes education. They don't bother specifying whether it's secondary education or tertiary education. The occasional bold litigant tries to say it's primary education, but that doesn't really get very far very often. But you do, when you're trying to construe what education means, when it's not been specified, this is the academic or the intellectual discipline that you're going to have to go through. What was known to the parties at the time, and what reasonably objectively did they intend? And that's quite difficult. And it really is it can lead to lots of money being wasted if you haven't drafted these things up pretty carefully to begin with. So that's the first case, Dahali. I would recommend you read it. It's not a particularly long authority, but it is quite an interesting lesson in how Chancery Division judges can occasionally get waylaid by things that the family lawyers see as being pretty obvious. The second case I want to talk about, or the second issue I want to talk about, again, not COVID related, you'll be pleased to hear, is pensions. And I want to talk about this case of W&H for three reasons. One, it's very interesting. By interesting, I mean interesting for family lawyers. I'll make that quite clear. One, it's interesting for family lawyers. Two, it is a judgment with real teeth and real utility from that's not come out of the High Court of First Instance. It's from Judge Hess, who used to be District Judge Hess down at the CFC up to, 5 years ago. I think he's now sitting mainly in Portsmouth. He is head of very involved in the pensions advisory group work. He's very close with Mr. Justice Mostyn in the drafting project, and is trying to drag the world of financial remedies kicking and screaming into the 21st century. And what you've got in W&H is that really super rare thing that we always complain that we don't have, which is a reported financial remedy case about a very bog standard set of day-to-day middle-class facts. And the day-to-day middle-class facts were they had a matrimonial home, £240,000 in equity, bit of debt, but what set this case aside apart from everything else was a very significant defined benefit pension of a couple of million quid. He had a basic salary of 150, pretty modest bonus. They'd worked together in the same company for a while. 15-year marriage. She was, I think, 50. He was in fact slightly younger. And it raised the issues that we see a lot in these kinds of cases. Is it right to target the capital value of a pension or the income value of a pension? Still no clarity on that, although there's a bit of guidance here or there, and this pushes it forward. The big thing, the second point, should the court exclude pre-acquired pensions? with the pension of 2.2 million, finally we have an argument where in a middle class case where pension interests might well exceed need. In those circumstances, can you exclude non-matrimonial pension? And to what extent should the court, and this is the phrase uses, disaggregate pensions and engage in offsetting? Personally, I put my cards on the table. I think offsetting is absolutely pointless unless pensions are in payment or people are rather old. And I do not understand why we still standardly ask people, experts, we pay them money to work out the level of capital, the level of transfer required to equalize capital values when we all have calculators we're perfectly capable of using ourselves. Now, whether you treat a pension resource as an income resource or as a capital resource, there is, says His Honour Judge Hess, no one-size-fits-all answer. It's relatively fair to use capital, he says, if the pensions are small or if the parties are young or the future income projections are unrealisable. So far, so good. The PAG, the Pensions Advisory Group that he had written, said a lot of this case is about him telling himself how well he did in the Pension Advisory Group report. But nevertheless, it's also a very useful summary of that report. Many of you will have tried to, when it first came out, will have excitedly downloaded it, seen that it was hundreds of pages long. And actually now we have His Honour Judge Hess now distilling the important bits for us in this judgment. He says, when you are thinking about needs cases, and in pension cases, there are very few middle-class cases where pensions genuinely do exceed need. You're looking to, if not equalise income, you are looking to apportion the income. But when you are apportioning income, one of the things that people always forget about are things like pension credits and other potential benefits that may be lost when we're working out how to do that apportionment. But nevertheless, in needs-based cases, you're focusing on the income generated rather than the capital. He says, where there are bigger pensions knocking around, where needs, he says, are comfortably met, they're less interested in drawing a distinction between pension and non-pension assets because there are other assets that may also be deployed. This is relating back to the decision that was made by Mr. Justice Francis, really, I don't know, 4 or 5 years ago, after the Taxation of Pensions Act, when he said, look, once you hit 55, you've really got a cash fund subject to some tax rules that you're able to take out once you hit that level. And that blurs the line, he says, between cash and pension. Now, the important part of that, I think so far probably so straightforward, but the next bit is the bit that I think is particularly interesting. You see, on one view, says His Honour Judge Hess, identifying pre-marital pension or non-marital pension is just the same thing as identifying non-matrimonial property, and we all know that it's not subject to the sharing principle, and that it can only be invaded in specie if there is a need to do so. And in principle, that's fine. But how do you do that? Because people don't contribute the exact same amount of money into their pension throughout the entirety of their life. One of the particular problems is that people tend to earn less money when they are younger, and they earn the slightly bigger bucks when they are older. So if you had 10 years working for a company as a single person, you then meet and marry your spouse and have 10 years working for the same company as a married person, it is very likely that the total amount of pension you would have put in during the first 10 years when you were single is likely to be significantly lower, just because you were earning less, than the pension that you put in when you were that bit older and that bit more established. I say at the bottom as well of that slide, it's also, I use the phrase mathematically naive. I probably shouldn't have used such highfalutin terms, but it is true. If I take two £10 notes, put one into a pension in 1990, one into a pension in 2020, we're now in 2021. Which of those two £10 notes is now worth more? Well, it's obviously the first. Now, that's a bit of a tricky balance, because on the one hand, you would have been earning less during the early part of your pension contribution. But on the other hand, even though you put in less, the effect of inflation and the fact that the pension company has invested it is going to make it potentially pound for pound more valuable than the stuff that you put in more recently. So if you are troubled by doing this process in a sort of mathematically precise way, it is a much more complicated calculation than first appears to try and work out exactly which bit of it. It's easy, forgive me, it's easy to work out what, as it were, what was non-matrimonial. It's easy to work out and just go through the pay slips. It's easy to work out how much was contributed, but how much that contribution is now worth is a more complicated question. Now, and that's what His Honour Judge Hess says in the penultimate paragraph that I have put. Oops, having kind of put myself on mute, I forgot to turn my phone off. So when an apportionment is made, the straight line methodology, he says, probably isn't the fair way of doing it. And there needs to be some caution to be exercised before using it if other fairer methodologies are available. Now, the PODE is the Pensions on Divorce expert. There's been a lot of chat on Twitter in the last 12 to 18 months and a real drive to ensure that pension on divorce experts sign up to a particular code. There is a great variety in the quality of work done by pension on divorce experts. Some of them are, I've seen some very sloppy reports who say things like, well, you know, if I give you 25%, if 25% of your pension goes over, then 25% of the income must necessarily go over. That's not quite the same thing. You've got to allow for ages and you've got to allow for the scheme rules and all the rest of it. And it's always a difficult balance because it's worth paying properly for a proper pension expert because they understand these sorts of issues that are involved. My personal preference, for what it's worth, when you are trying to segregate out premarital pension, is to look at the fact that all a pension really is, for most people, is the right to an income in the future. And how much of that income, if you've got £100 a month coming out from your pension, how much of that £100 is referable to contributions that were made when you were single, and how much of that contribution referable to when you were married? You see, nobody ever bats an eyelid when you talk about post-matrimonial pensions, because you always say to your client, well, we're splitting the income rights that have accrued as at today, and that what you do with your pension, whatever earnings you make going forward, that bit of your enhanced pension thereafter, that's yours. You can keep that. So nobody has any difficulty ever with how you isolate post-matrimonial pension, but isolating pre-matrimonial pension or non-matrimonial pension. I have a case at the moment where somebody has inherited a pension fund, which if you think about it is quite a difficult and technical problem. So just get proper pension on divorce expertise advice and come and see Graeme and me, and we will tell you the answer.
Just seen in the chat, Max, there's a question that's come up.
Okay.
If it is a defined benefit scheme based on number of years, is a straight line proportionate basis okay?
If it's a defined benefit, yes, but you will still have to allow for the fact that it won't be, the line won't be straight, it will still be slightly curved on the basis, a defined benefit. The assumption is always that the amount of money that goes into your pension, or the amount of benefit that you accrue, is probably more accurate, in relation to your pension, is a function of your salary. And the higher the salary under a defined benefit scheme, the greater your income units at the other end when you retire will be. So on the assumption that let's say you start as a junior civil servant, if you spend 10 years as a junior civil servant and never have a pay rise and never go into a different pay grade, then you probably could take more easily a straight line apportionment. But if you spend 3 years and then get a promotion, another 3 years, another promotion, even though you've still got the same defined benefit scheme, you've earned more of your income in the later years than you have in the early years. So that curve is really important to bear in mind. So with a DB, this is a long way of saying, this is a very long-winded way of saying, it's easier to do it with a defined benefit scheme, but it's still not a pure straight line equation. Now, offsetting, but it's an interesting question though. It is an interesting question. So offsetting, which should be the thing on your screen at the moment, I very, very rarely have I seen judges want to get their hands dirty in offsetting. I very, very rarely, I'd be interested to know, Graeme, whether you've had any contested cases where a judge has ordered an offset as opposed to simply approved one in a consent order. But all the statutory guidance is to stay away from it if at all possible. It gets very messy very quickly. It's the whole apples and pears thing. You're not comparing like with like. Hess says, undoubtedly, some people do choose to do that. And it's easier if you're older, and it's easier if there are other pensions knocking around. It can be easier if there are foreign pensions which work in a slightly different way and are closer to cash. But it's that whole Wells and Wells risk thing. On the one hand, you're buying an annuity, which is a terrible deal, says Mr. Justice Mostyn. Nobody would in their right mind would buy one nowadays. But on the other side, there's nothing else in the world that will give you that level of income protection. So it's a bit of a balance. But in my experience, in a modest money case, it would be very, very unusual to get involved in offsetting unless the parties were absolutely happy with it and didn't really care about the mathematical precision of it. But it does get very difficult very quickly.
I think just to answer that, Max, we tend to see it done more by agreement rather than
I think that's right. But judges hate offsetting because, and I think the reason, I think I can say it amongst these, I've had these four walls, but this, within the safety of this seminar, I don't think many judges understand it. I think they are very conscious that the maths becomes very, very complicated very quickly, and they're scared of being appealed. So they don't tend to want to do it. They're quite cautious beings. Two decisions, we're still in we're at county court level, we're at circuit judge level. Judge Robinson, again, used to be a DJ at the CFC or the PRFD, to those old enough to remember that. Again, two cases recently, again, very unusual to have reported cases from there, both of which say the same thing, which is that, again, that this was a big disparity in pensions in KM and CV. There was a police pension had trebled since the parties separated. The DJ had looked at the date of separation, said, that's what I'm splitting. Judge said, no, that you don't do that. You look at the value now, but you look at the income units that have been produced. RH and SV, again, the judge had equalised a CEV at the date of separation. And again, that was a mistake. But he does say, says Judge Robinson, much the same way, but in a slightly more floral language, nothing inherently wrong with aggregating capital and pension, but it's not a comparison of equal value, provided, he says, it's recognised that the orchard provides different types of fruit. It's not wrong to look at the division of the total crop. The provision must also be considered in assessing fairness. So, as I say, stay away from offsetting and remember how complicated the math can occasionally be when it comes to pensions. Now, unfortunately, I can't stay away from coronavirus forever. Otherwise, this talk would have been pointless. But I can talk about one particular case that struck my eye, or caught my eye rather, R&R, a decision of Nick Cusworth, QC, sitting as a deputy. This was decided about 2 months ago. And the interesting question here, and I think it's got a wider application, this was an interim maintenance application where these two had a lot of money. And the husband was making an application for interim maintenance for himself. And he said in his budget, well, I would like to have, please, £5,000 for a combination of restaurants, theatres, cinemas and concerts. And Cusworth said, but they're all closed. What are you going to spend that money on? When you are in a position of lockdown, your level of discretionary spend completely changes. But, says Cusworth, there is going to come a point where things unlock and where we are able to go and have dinner with more than one person who is also wearing a gas mask at the same restaurant, where we are able to go to the theatre, where we are able to do the things that we used to do. He thinks by later in the spring, you know, we're getting nearly there. Two things about this case. One, he raises the question but doesn't answer it. I suspect because he's only a deputy, but he curtails the husband's award to the level of income that he thinks is necessary for the life that he's able to lead at the moment. Now, was another case recently as well, which was actually about 10 days before this case, called Rattan and Kuwad, R-A-T-T-A-N, and Kuwad, K-U-W-A-D, if you have a pencil to hand. This was the case where, I can't remember who it was, some of the Court of Appeal said, Moylan said, you don't need to have a separate budget for your MPS. Sometimes your 4ME budget can be enough, right? Sometimes, because we were all used to being told by Mostyn in TL and ML, well, when you have to put a specific budget for your interim needs. And what Moylan says, the underlying assumption of that is that 4ME budgets are genuinely useless. They are a massive wish list and they don't help anybody. And actually what you want is a realistic budget for your immediate needs so that we can all know where we are. Moylan says, well, sometimes people actually, perish the thought, put in a rational budget in there for me, and that's perfectly usable. And so you don't always need to have a specific budget. But one of the things that certainly I found is that the cases that the cases that are now coming for FDR and now coming for trial are cases which began at about or before the time that lockdown started. And so a lot of budgets now are out of date, and we don't know when that budget's going to come back into date. So I think you're going to need to be careful when you are analysing a budget. Look at the date of the budget. If somebody puts in a budget in, you know, May of last year that says, I need £1,000 a month to go to the cinema or whatever it is, when all of that stuff is closed, it's going to bear no resemblance to the actual bank statements. And certainly what I've been seeing recently is that people are going through bank statements and saying, well, actually, no one's spending, not spending any money. Why do you need that much money in maintenance? And we're trying to bridge that gap between not being so tight on maintenance that there's just going to be an inevitable flood of variations the second that lockdown lifts, and not giving too much in maintenance that people are finding themselves not so much unable to spend, but that actually isn't in relation to the actual life that they're living at that particular moment in time. So those three areas of law that I've described, the first, De Harley, about construction of consent orders, second, H&W, about pensions, and third, this point about MPS in the time of coronavirus, I think are three things which all of us would be well advised to dig into a bit deeper. I think at the end of this, I think anybody who wants it, or frankly whether you want it or not, we may end up sending round these slides.
We will be doing that.
We will be, okay, fine. So if it goes into junk, then please go and fish it out. But you will be able to read through some of these authorities. I would particularly commend reading De Harley for its discussion about how you interpret consent orders. It's a really useful thing that we don't really spend much time on as financial remedy lawyers. All right. So moving away from decided cases, I want to loop right back to and hand over to Graeme in a moment about, whoops, about new clients. New clients that are coming through the door. Now, I've included there a stat from YouGov. YouGov is one of my favorite websites because it is just composed of surveys and reports and data and numbers. And if you like data and numbers like I do, then it's a little minefield. It's a gold mine. Sorry, it's the opposite of a minefield. It's a gold mine for interesting bits of data. When I spoke to Graeme about what is the makeup, what are the issues affecting clients as they come through the door, the first thing he said to me was lots of people's mental health. And I don't mean in a sort of grand psychosis way, but lots of people's sense of purpose and joy for life and stress and anxiety, that stuff, that's what we're seeing much more than we ever used to. And the data, and this is taking, you'll see the bottom right-hand corner of that slide, that was back end of October, over Halloween. How has coronavirus impacted on your mental health? Well, you know, it seems to, interestingly, it's hit the 16 to 24-year-olds quite bad. The 25, 39-year-olds a bit harder. But actually, those who are 60 plus seem to have either, a lot of them, it's had no impact on them at all. There are a number of people aged 16 to 24 for whom it's had a positive impact on their mental health. I suspect probably because they're not at school and didn't have to do exams. I suspect that's a lot of those people. And that finals were cancelled and everyone got an A star and we all went home. So but there is nevertheless, it's a much more complicated and nuanced picture, I think, than anybody really gives it credit for. And if you'll forgive me a bit of a journey into some numbers, I promise this won't take very long and it won't hurt very much. But I want to show you one more thing from YouGov before I hand over to Graeme. Now, this is the most fantastic piece of data. This is, again, a YouGov survey, and you'll see the question it's asking is this: thinking about your romantic relationship or relationships during coronavirus, which of the following have you experienced as a result of it? Please select all that apply. And then it asks answers by England and various other countries as they go along. Now, two things I want to show you, or several things I want to show you. Number one, that whole left-hand column will add up to 100, right? So 100% of people. Of those, 40% of people in Britain said it's had no impact on their relationships. 24% of people said they haven't been in a relationship. So fine. So 40 and 24 is 64. About 2/3 of people in England, give or take, are reporting that coronavirus has had no real impact on their relationships. Okay? About 2/3. So the question is, what about the remaining third? 15% of people said their relationships have ended, but 15% have said their relationship has got stronger, right? That is a really interesting statistic. Of all the people for whom coronavirus has made a difference, it's made some relationships stronger and some relationships weaker. And this is one of the things that Graeme and I, because we're big-headed, successfully predicted at about this time last year, was that because people aren't commuting, because people aren't going to work, because working from home does have some benefits, particularly if, like me, you've got young children that you don't mind hanging around, you quite like. Actually, some of those people who were a bit 50-50 about should they separate, lockdown has saved their marriage because they're not going on work trips, perhaps being ultra cynical. You know, when everybody's locked down, you can't carry on your affair, or the temptation to go and have, you know, you're not in the pub, you're not getting drunk, all these different kinds of things. There have been terrible stories about domestic violence. I'm not minimizing those at all. What I am saying, however, is that it seems to have pulled in two different directions. And it's not as simple as saying it's all been terrible, the stress has caused an enormous amount of litigation. I suspect that what's happened is that those couples who are separating with a bigger bang than they were previously. But actually, in terms of the raw numbers, what you're seeing is that it's made some relationships better, some relationships worse, and it's about the same number of people at about the same level. And then I want to show you, looking at this bit here, this 15 and 15, those who have ended up become strained, those have, I just found it interesting. The difference between France and Germany. And Italy, forgive me. Slightly more people have found their relationships in France were ending. I'm not going to speculate why. But I will say that in Italy, which got hit really badly, really badly, actually, more people are reporting that their relationships have got stronger rather than weaker as a result of coronavirus. Now, we can speculate as to why that's happened, but there is something going on, I think, about in places that have been hit really badly by coronavirus. We remember, I mean, it's hard to forget the sorts of scenes that we were seeing in February of last year, of these sort of war zone scenes in Western Italian hospitals. But actually, more people are reporting that they are in healthier relationships than they were previously as a result of that. Whether it's the lockdown, whether it's the fact that you've had a sense of your own mortality and you're kind of clubbing together or not, I don't know. Whether it's all going to change when the restaurants reopen, again, who knows? But it's not as simple as saying that Corona has been bad for relationships. There are some relationships that it has helped. So on that point, I want to hand over to Graeme at this point, because he, unlike me, sees new clients. They come to me several months later if it turns out that the solicitors can't help. But I'll hand over to Graeme, because I think he would want to talk a little bit about the new clients that are coming through the door. To Graeme.
Yeah, and I just want to say here, this is my own experience, and I know there are lots of solicitors on this call, and they will have all had their own experiences. So I say by no means this is everyone's experience. I know we can get a run of cases, and that's just how it goes. But I'm just sharing my experiences, and also in answer to the first point about is there a distinction between men and women? Men and women can experience the same feelings. And I'm not going to differentiate between them on a sort of gender basis either. But in terms of what I've noticed from my client base is that I felt that men were reporting feelings of depression and lack of self-esteem, and that had resulted from the lockdown. And they were feeling the effects of employment pressures. That could be furloughing or threats of redundancy, or in fact redundancy itself. We've also encountered as a practice women reporting concerns about domestic abuse, the need to take action swiftly where we had to, and also reporting of concerns about coercion and control, which is an important part, I think, of vocabulary, and it is all part of the process of actually understanding what domestic abuse is, which has become a much more nuanced area of law than, I certainly knew about when I entered into practice. Coming up to 25 years ago. Questions raised there by Max, these are Max's questions to me really. Has there been a rise in maintenance variations? I can say yes, absolutely there have been. And some of those cases have gone to court. FLA applications, yes, and we are largely a private practice, but we have been running those applications or defending those applications. In terms of children work, we do private law children work only. And I would say my view about that is that those cases tend to get a bit more stuck than they did. Obviously, we try and get them through the courts if we're negotiating through court. But it's the effect of COVID. And I think it did make people more positioned, particularly in the earliest stages of COVID, and in the early parts of the guidance that was given, because the president made a very definite decision about the child remaining with the parent with care and certain defence being available in that situation. Then the next section, which was about popularity, I suppose, of those three processes, again, don't want to generalize, but I do sense that private FDRs are becoming much more normal. It's not just my experience, it's what other family lawyers tell me, it's what counsel tell me. It's actually becoming the norm in a lot of cases. We're seeing actually an attempt made to streamline the first part of the case. So to avoid the first appointment, do it by written directions only. That's when you're cooperating with the other side, and then you run it to private FDR. So you're effectively privatizing the process. And I can also say from experience in private FDRs that they have been successful. You get a considered decision, and I believe it's a higher rate of success. But of course, it works for the right client in the right situation. Arbitration, I'd like to say something happier about that. I think it's an excellent process. I think it's a process that should be developed. It should be more available to people who don't have lawyers. But I'm afraid I have to say, I think it's still a slow burner. It's been around a long time. I think I remember doing a presentation in Central London with Max many years ago about arbitration. It just hasn't taken off. And I think that's down to lack of knowledge generally. I think it's lack of knowledge, including family lawyers, possibly judges, but for whatever reason, it just hasn't taken off. But I think it is going to develop. I think it's going to be very important in the future. And in terms of mediations, I'd say I feel they are being attempted more, and that video conferencing has greatly assisted with that. What I'm not so clear on is whether the success rate is any higher. And I don't say that as a criticism. I just don't know whether it achieves more success. Obviously, we want to encourage people to take up these processes, and it will assist them in getting a settlement that they want, but it has to be a case that's suitable. And I do feel that it has to be a voluntary process. I think that incentivization is important. And I read yesterday, there's a latest judgment by Nick Allen in Max's Chambers, where there is that sort of encouragement going on with part 3 of the FPR. In terms, do clients have more disposable cash? That's an interesting question. I think some of them do. I can see that from their spending habits. I can see that also from how, dare I say it, how quickly they pay their bills, including our bills. But also there is additional expense on the household because everybody's stuck at home. So they're spending more money on things they're using at home. And I think that we can't underestimate the pressure that some people feel when they are working in service industries, and they're under enormous pressures. And I don't make light of that at all. Some people have been under severe pressure for a long time. And I suppose the question that Max asked is, what happens with our inquiries? I suppose I was a bit hesitant in sharing that. I think everybody has the same experience. We do get a lot of inquiries. We had a lot of inquiries before the lockdown. And I think that actually the issue of whether those inquiries progress is more dependent on how people are in terms of pacing, where they feel in the process. And there's a famous grievance, not grievance, I've lost the word there, but a grief cycle in terms of how people are feeling and when they're ready to go to a lawyer and when they're ready to resolve matters. And perhaps the COVID affects that as well. But it really goes on to the next question, which is how resilient is family law as a business? Well, I think family law has been robust and resilient. The president commented last year that at one stage, the UK Family Court was the only court that was working in the world. I don't know if that's backed up, but it was an interesting statement he made. But I think I just urge a word of caution about all of this, because I don't think as family lawyers we should get carried away with the fact that we're busy and suddenly our industry is working fantastically well. And I say that because I think there are changes afoot, and they're changes that we saw before the pandemic, and they're changes that will result from the pandemic in terms of what the consumer wants, what they're going to demand, because I don't think it's so much about us producing our processes for them. It's going in the future, it's about more of them saying to us what they want from us. And I think we have to accept that there has been a certain amount of de-lawyering of the process. There will be more of that when no fault divorce comes on board with the development of the divorce portal, and also technological advances that are going to change the way that we practice in future years. Although if we're on top of that and we master that, then I think there's a bright future ahead. So I'm going to go back to Max now, who will go through the next few slides.
Thank you. It is interesting. So what is the future? Well, I'm sorry about the bad graphic. I just looking for a thing and I found it online. There's a wonderful article by a man called Noah Yuval Harari, who is an academic who specializes in projections about mankind's future. He wrote a book called Sapiens and a book called Homo Deus. Very, very good books. You'll find them in the non-fiction part of any decent bookshop or Amazon. And this was him writing in the Financial Times in March of last year, about a year ago. And he was right that many of these short-term emergency measures will become a fixture of life. You know, the cloud video platform and, you know, dare I say it, fixed times for a court hearing, as opposed to getting there at 10 and waiting all day. That's the nature of what an emergency does. It fast forwards historical processes. I've been saying for a while, and I've talking to people about this for a while, what coronavirus has done is to thrust us unpreparedly 10 years into the future. We are, 10 years from now, if we hadn't been for COVID, we would have been having Zoom hearings. We would eventually have got rid of the need to go by train for Newcastle upon Tyne to be told that you're adjourned because the judge can't find your file. We have, things about much more engagement of expert witnesses remotely, even if the trial is happening in person. Do you really need to see the whites of the eyes of some professor of something or other when they've got better things to do and they can zoom in remotely? So a lot of these things, we've had a massive jump forward 10 years. And I think we've actually, all of us deserve a bit of a pat on the back. I think we have done very well. We have, I remember April, May of last year, some of us were running around like headless chickens. The world was over. What were we going to do? But actually, we took a deep breath and we made it work. And that's been an incredibly impressive feat. Whether or not, as Graeme says, the English family court was the only court that was open, we certainly stayed open for a lot longer, and we managed to get this. We did manage to get things going, and I think that that's to do with a lot of the English judiciary, who come in for a bit of a bad press in the Daily Mail, but they are a very hard-working bunch. You don't go to the judiciary for the fame or the money. You go in because you are bright enough and because you have a genuine belief in public service. I've been very impressed by them. Even the rubbish ones have behaved impressively. And I think that's only going to get better. Now, I gave a seminar with Graeme about this time last year, April last year. And it's just an interesting experiment to look back. And this is a slide. I've just cut and pasted a slide from my seminar with Graeme last year. And the question was, in April, so by this point, we've been locked down for 6 weeks, and Joe Wicks is on telly, and we're out clapping with our pots and pans at Thursday afternoon at 8 o'clock, and we're all thinking, what's going to happen with the world? And I gave a seminar with Graeme, and we were thinking, well, what's going to be the future? What's going to happen? And we thought those who are planning for further children might want a delay. And actually, if you have, if you get the Times or the Times app on your phone, there happens to be an article today about how birth rates are falling. Because some people thought that, oh, we're all locked down, everyone's going to be having sex and having children. But actually, if you think about it, who on earth is going to who is having a difficult time, who's going to actively say, well, now's exactly the right time to start having children? Be a ridiculous thing to do. On the other hand, there was a concern about the fact that most birth control is made in China, and all the Chinese factories closed down. And was there going to be a glut of children as a result of that? The answer was no, we called that wrong. All that said, the far bigger demographic shifts are going to come after lockdown, pubs and clubs reopening. I had this sort of Hogarthian vision of everybody suddenly rushing out and, making love in the streets the second the bars reopened. I can admit I'm wrong about that one. But still, we'll see what happens this time. Maybe I'll be proved right second time. People having affairs will suddenly all have to stop. Unplanned births and a big glut of Schedule 1 claims in 12 to 18 months, i.e. this summer, this autumn. I don't think that's happened. I think people have been, I think the novelty of lockdown wore off pretty quickly. And people began to realize that actually we're in for the long haul here. And actually, you know, it's not a great time to start bringing a child into the world with that level of uncertainty. But COVID wouldn't vanish. So at least I'm right about that. Again, this was from another slide from my lecture with Graeme last year. And here I think we called it a bit more accurately. People's earning capacity, what sectors are going to survive? I would not want to be an air hostess or a travel agent at the moment. I'm not sure I'd want to work in a hotel. I'm not sure that many restaurants are going to survive, in the pub trade, in the service trade. Some people have made a lot of money, dog breeders, for example, out of lockdown, but they are in the minority. A lot of sectors may simply not survive. I fear, and I can't believe I'm quite saying this, I fear for the future of public transport, because if anybody's actually had to go and get a train to town, you are getting a seat now, not just at 8:05 in the morning, not just any seat, you've got the whole pick of the carriage at exactly the time that everybody was going in before. TfL, the buses are losing money hand over fist, which means that there's going to be yet more chronic underinvestment, and some of these companies go bust. It's going to become very difficult to get back into work in the same way. School fees, well, schools. It's interesting. A lot of schools were offering. They believed that in order to offer value for money for their fees, they had to offer live lessons, and then they realised that meant that kids were staring at screens all day, which is what they were telling their children and parents that was exactly the wrong thing to do, stare at screens all day. So we haven't really seen much of an impact on schools. Prenups, I've seen arguments about prenups get more difficult because nobody knows where we're going to go. But reductions in savings and pensions is a more difficult point. As we've said, some people are earning less, but some actually are earning what they were earning before, they just can't spend it. I think we are going to see changes in maintenance. The last financial crisis, the credit crunch led to the death of the joint lives order. And I wonder whether we're going to see further hits as a result of all of this. But remote mediation, and I think remote mediation has been a very powerful thing. Certainly many mediators have said to me, the fact that you can mute somebody is huge. And the fact that you can have your camera off if you don't want it off is huge. And actually, you can have somebody who is ranting and raving about the unfairness of the world and still retain a perfectly civil mediation if they just can't be heard by anybody else. So I think that's been quite a useful thing that we have seen coming out. What might be here to stay? I think remote hearings are here to stay. I think WhatsApp during hearings are brilliant. I would urge everybody to have a WhatsApp channel. I'd also urge everybody to download WhatsApp for the PC. It still works through your phone, but your PC will be showing your WhatsApp as you're going through it. For those people who can type more quickly than text on their phone, it's an absolute lifesaver. It also allows, as one client did, to start sharing stupid dog pictures halfway through an FDR, which was entirely unhelpful. But nevertheless, you know, it's a bit more informal and you can chat. And now I'm constantly saying to judges on remote hearings, oh, Mrs. Bloggs, would you mind sending me a WhatsApp and giving me instructions? Tell me what you think about that. And you ask them online, and then you get a WhatsApp 5 minutes later. Sorry, I was making a cup of tea, I had the sound turned off. You know, fine. But that's been incredibly useful. I think paperless working's been huge. I think that I can't remember I have been extraordinarily busy in the last 12 months. I have had my second ever highest billings in a year. I've not received a single paper bundle for 12 months. It's been an absolute godsend. I can do it, or it takes a while. You buy a second screen, it takes a while to get used to it. We're not going back to paper bundles. E-filing, e-service, I'm now seeing regularly orders. You may serve this by Instagram, you may serve this by email, you may serve this by Twitter. You know, that was the most radical thing 5 or 6 years ago, the idea that you might serve otherwise than by sticking it in an envelope with a postal stamp on it. So we've really made some serious progress there. Work-life balance is a bit of a double-edged sword. On the one hand, I'm not going into work. On the other hand, I have no division between work and home. So it's a bit of a balance. I could spend 18 hours working in my house. Am I at home? Am I at work? That's a difficult question. So that needs a bit more thought. And the client base, I think that perhaps more so for barristers than for solicitors. I was in Prestatyn a couple of weeks ago on an argument about caravan park in Wales from my office. And I didn't have to spend 4 hours on the train there, 4 hours on the train back. I'd have to deal with the type of coffee that you get at national railway stations anymore. Real positive movements forward that I'm sure you are very happy about.
Yeah, I just wanted to say I think all of that is true. And certainly the biggest change, I think, to us as solicitors has been the paperless working and the remote hearings. Although with the remote hearings, I do think final hearings with cross-examination are better done in person, and also remote hearings need to be done in a safe environment. So there's a bit of tweaking to be done, improvements in technology, but in terms of the push forward, it's made a massive difference. And I think you're right, Max, we're not going to go back.
Yeah, I certainly hope we don't. I think judges, they're lovely people, but they're quite slow, and they are, I think, slightly hidebound by their internal processes. You think about what the back office looks like at the Barnet Family Court. Back in the day when you could go and speak to that nice Scottish lady who used to work there. I can't remember her name. And then you look at some of the other. I once had to go into the back office of the CFC where they keep the files because we needed to go and fish something out and we couldn't work out what it was. The judge said, just come back and and I got a little look around and it's chaos. It's absolute chaos down there. And it's going to take some time to digitize stuff. But actually, once you just press a button and it's there, occasionally, if the judge says, but I haven't got a witness bundle, fine, you email one, right? I can't find that particular document. Okay, here it is. Screen share. I was in an FDR a couple of weeks ago, and we screen shared an asset schedule, and I showed someone the net effect of various bits and bobs, and that would have taken me an hour to describe. But actually, I can just show it on the screen, and it's just brilliant. But this slide here.
Just to say, Max, apparently from some local practitioners, the lady's name was Mary or Marie.
Mary. She was absolutely lovely, and you would ask her a question, she'd give you an answer, which is just priceless. And even if the answer was just no, you can't, fine. At least I know, right? Can I go and see this judge urgently? No. Okay, fine. I don't have to wait for 3 hours for someone to come and tell me. She tells me there and then. But it used to be a really well-run court. Right, but the sooner they digitize, so much the better. Anyway, but thank you for whoever remembered her name. She's a very nice lady. Now, this article on your screen now, a man called Neil Robinson, he's a law lecturer, Staffordshire or somewhere, I think, wrote an article in Family Law last month about mediating in extraordinary times. And what's interesting about this is I'm not a mediator, but I'm a big fan of it. And I think that people ought to read it if you're interested in family law. What's interesting, though, is he makes the point that a lot of stuff has happened at the same time as COVID. In particular, we had the whole George Floyd thing. We've had the Black Lives Matter thing. We have had a much greater understanding of coercive control. We've had a much stronger understanding about privilege and how privilege is abused. We have had, to some extent, a greater understanding of issues of sex and gender, and as well as greater arguments about the role of sex and gender. None of these things are directly related, I think, to COVID. But nevertheless, they've happened at the same time as COVID. socially, I think it's important to understand that the world hasn't stood still. And that one of the things that this article does quite neatly is to discuss, for those who are in mediation, who are mediators and who are engaged in that kind of thing, you know, you're constantly looking at your own unconscious biases, and you're constantly looking at your own assumptions about the world. And this is a very useful article to help people to reflect on the fact that actually, while we've all been locked down, a lot of people have become aware of a lot of things, coercive control particularly. And when I first started this job, everyone was a stalker. And then everyone became a narcissist. And now everyone has become a coercive controller, right? It goes, it's not so much that it goes through fashions, but it does, there's a sudden rush of appreciation of a particular topic. And people are talking about, and there are judgments about coercive control in a way that there weren't a couple of years ago, even though the legislation changed in 14 or 15. Keep an eye out for a decision from the Court of Appeal, expected in the next couple of weeks, for what it's worth, about the use of Scott schedules in domestic violence cases. I was talking to one of the counsel that was involved. One of the things they're saying is that it's likely the Court of Appeal are going to say it is pointless to have a Scott schedule when you're making an allegation that somebody is a coercive controller, because it would have to be so long as to be completely unwieldy. You know, if you had to list every single time he put you down or belittled you, or one was put down, one was belittled, forgive me. If you had to list every single time that somebody wasn't allowed access to their bank accounts or was made to dress in a certain way, it would just, you can't do it. So the likelihood is that there's going to be a move to something closer to threshold documents like you see in care proceedings, being used instead of Scott schedules in domestic violence cases. I think that a lot of that has happened because I think people have had the time to think about their own behavior and their own biases. I think when people are very, very busy and there's lots going on in the world, I think people don't tend to sit back and reflect. But actually, I find that this period has allowed a lot of people to reflect on things. And this article by Neil Robinson, who I have no idea who this person is, I haven't met them, but it captures very nicely what's been going on. All right. The final thing, again, that I think we're going to need to recognise, what I want to leave you with is, I like to leave people with a short little video clip. Most of you have seen the various Zoom fails about things that have gone wrong during Zoom hearings. It's quite nice to end with something that happened in a UK parliamentary context. There are things we need to improve. Professional well-being, as I say, do negotiations separately, but Zoom and CVP etiquette. These are things that we particularly need to improve, as this little clip will show you.
Yesterday I posted on Twitter, the bosses of ITV are coming in, what would you like me to ask them? I got various suggestions, some serious, some less so, but I thought this one was very interesting from somebody called Henry Warren, and he says this: could you please ask them why they're not turning on the subtitles by default on children's TV? It's been shown to double literacy. YouTube, which you mentioned in Caroline, already do it. Kids do it, YouTube Kids do it, and the BBC are also now embracing this. Why, and I apologise for my cat's tail, why are you not doing this by default? Rocco, could you tell them?
90% of CITV
Cats are guaranteed.
90% of CITV content.
Can I just say, I just do that to people appearing before us. It's particularly effective with cabinet ministers.
Very efficient tactic.
I'll have another go.
There it is. So make sure, if you do have a cat with a bushy tail, you keep them well out of your Zoom hearings. But listen, thank you very much for listening. It's been I quite enjoy doing these kinds of things. I can see some things in the chat, actually. Are there any, but I can't see where the chat is. Are there any questions that people have been raising, Graeme?
I think we had that pension question throughout, but actually I haven't seen any questions arising. But what I'll do in the meantime is I just really a vote of thanks. Just thank you for all your time in putting this together. I certainly learned a lot on the new black letter law. Very interesting developments there, particularly in the world of pensions, which I think has changed things, and also on maintenance cases. Certainly a feature in my cases now is this check of bank statements. That seems to be happening as a matter of routine. So thank you for noticing those trends. Thank you for doing the research on the stats and also the contrast and comparison with this time last year. I'm hoping that we won't be having a seminar like this next year, and what we will actually be doing is seeing you all in person and welcoming you back to our offices when we should all be open, even though the world's changed. So thank you everyone for attending. Thank you very much, Max, and that brings to an end today's webinar. Thank you very much.
Thanks, Graeme. Thank you.